Good afternoon, good morning, and good evening to all of you. I am a CA Radhika. In this video, we are going to discuss about Article 22 of the Part 3 of Indian Constitution. Article 22 is also one of the most important article which protects our liberty. So, in the entire session, we are going to discuss about this article. So, you get the fundamental understanding of this article. So let's start the session. In this session, firstly, we will proceed by bare reading of the article. Then after that, we will go to understand what exactly this article is providing to us. Okay, now go start with that. Name of that article: Protection against arrest and detention in certain cases. The word certain cases is much more important here. Now start reading it. No person who is arrested shall be detained in custody without being informed as soon as may be the grounds of such arrest, nor shall he be denied the right to consult or to be defended by a legal practitioner of his choice. The clause number 2: every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of magistrate. No such person shall be denied in custody beyond the said period without the authority of magistrate. I hope to all CA students that they are able to recognize this entire para in their law section. Law, whenever you read the company law, there is a certain provisions are also similar like that. In income tax as well, you have read it. I hope you get that hint. Now third clause is: nothing in clause number 1 and clause number 2 shall apply to any person who is for the time being an enemy alien, or any person who is arrested, detained under any law providing for preventive detention. Clause number 4, which has been added or amended by a 44 Constitutional Amendment Act 1978. No law providing for preventive detention shall authorize the detention of a person longer than a period of 3 months, unless subclause A, an advisory board consisting of persons who are or have been or are qualified to be appointed as judges of High Court has reported before the expiration of the said period of 3 months that there is in its opinion sufficient cause for such detention. What is more important here? Sufficient cause for such detention. There is a proviso in that, provided that nothing in this subclause shall authorize the detention of a person beyond the maximum period prescribed by any law made by Parliament under subclause B of clause number 7. Clause number B: such person is detained in accordance with the provisions of any law made by the Parliament under subclause A and B of clause number 7. Clause number 5: when any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order as soon as be communicated to such person the grounds on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order. Clause number 6: nothing in clause 5 shall require the authority making any order as is referred to in that clause shall disclose the facts which such authority considered against the public interest to disclose. What is that public interest word? Clause number 7: Parliament may by law prescribe a circumstance under which and the class or class of cases in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of clause 4 subclause A. Clause number B, the maximum period for which any person may in any class or class of cases can be detained under any law providing for preventive detention and the procedure followed by the advisory board. I hope you all get the brief understanding what this article have. Just a brief. I don't want you to understand the each and every word, but the brief understanding of what is we get it that Article 22 consists 7 clauses. 1 to 7. Now we get the bifurcation of that to understand the entire article, broader and conceptual view about it. Article 22 consists of 7 clauses, 1 to 7, out of which clause number 1 and clause number 2 tells about the preventive detention. Clause number 3 states about the applicability of this article. The remaining clauses, clause number 4 to 7, talks about the preventive detention. Now we are going to discuss these words one by one. Or you can say that in a sum of way, that first part of Article 22 deals with the ordinary law or the preventive detention. The second part of that article deals with the preventive detention, and first one deals with the punitive detention. I hope you get the brief, a little bit understanding of it. Now we get more dive into this topic. For the understanding of this, we need to understand the word detention means. Detention means that whenever you violate any law or you do anything which is against the laws or violating the laws, in that case either you get under the police custody or the judicial custody. So there are two types of detention: punitive detention and preventive detention. What does the punitive detention mean? Punitive detention means to punish a person for an offence committed by him or her after trial and conviction in a court. किसी भी पर्सन को पनिश करना कि उसके ट्रायल और उसके कन्विक्ट हो जाने के बाद कोर्ट के अंदर में, उसे प्यूनिटिव डिटेंशन कहा जाता है. दैट कोर्ट का कन्विक्शन ऑर्डर आ चुका है दैट द सो एंड सो पर्सन हैज बीन गिल्टी फॉर सो एंड सो एन ऑफेंस. इन दैट केस दैट पर्सन हैज टू बी under detention of the judicial custody. The second one is the preventive detention. Preventive detention, that we are suspicious about that this person could have been create so much disruption or affecting the national security or public maintenance or security order. Whatever the reason may be, that person could have been affected or could commit any crime. In that case, to make sure that or to prevent such events from happening, in that case so and so person has been get detained by the authorities. This is known as the preventive detention. For example, you can understand in a very simplest or easiest way that in our houses as well, our mother has keep the chocolates and ice creams in the freezer and over a particular secret place where you cannot easily able to get it that. So for the purpose of that, you won't be able to get the extra and you won't be able to take the extra share out of it. So this is also preventive detention. Similarly, the concept is preventive detention is like that. It is a precautionary measure and based on suspension that this person could have been do, so this can do such kind of things, so that for the purpose of safeguarding we detain that person. So there are two types of detention: punitive and preventive detention. I hope you get the understanding of these two words. Now we can proceed on our article. So no person who is arrested in the clause number 1 is said, किसी भी person को arrest नहीं किया जाएगा. That no person shall be detained in a custody without being क्या so informed. 5 things need to be informed. Here it is that the grounds of arrest, the grounds कि उसको किस बात पे arrest किया जा रहा है, what are the grounds of arrest. Right to consult and to be defended by a legal practitioner, that he has a shall never be denied, नहीं किया जाए क्या right consult करने का अपने legal practitioner से, और defended by a legal practitioner, that उसका अपने representative को hire कर सकता है. What are the 3 main in the clause 1? What are the 3 safeguards has been provided in ordinary cases or a punitive detention? What is that? The grounds of arrest must be have been informed, the right to consult and to be defended by a legal practitioner. Now In the clause number 2, two more safeguards has been also provided, that every person who is arrested and detained in a custody shall be produced before the nearest magistrate within 24 hours of arrest. यानी 24 घंटे के अंदर उसे जब अरेस्ट किया गया है, एक्सक्लूडिंग द नेसेसरी जर्नी टाइम वट एवर इट इज, उसको एक्सक्लूड उसे 24 घंटे के अंदर मजिस्ट्रेट के सामने प्रेजेंट करना होगा. नो पर्सन शैल बी डिटेन्ड इन कस्टडी बियॉन्ड सच पीरियड, यानी 24 घंटे के बाद आप उस पर्सन को कस्टडी में नहीं रख सकते. तो दीज आर टू मोर. सो इफ वी कैन टॉक अबाउट इट एंड समराइज दिट्स, clause number 1 and clause number 2 provided the safeguards that can be allowed in the ordinary laws or a punitive detention. In that case, what are these? First, the right to be informed about the grounds of arrest, the right to consult and to be defended by a legal right to consult and to be get defended by legal practitioner. Fourth one, it is that it should be produced before the magistrate within 24 hours of arrest, and the fifth one, that right to be released after 24 hours unless the magistrate authorities have been given the further detention order. यानी उसे 24 घंटे के अंदर अंदर रिलीज करना होगा. अगर फर्दर डिटेंशन ऑर्डर आए तो देन ही विल बी मूव टू द पुलिस कस्टडी, जुडिशियल कस्टडी, एज पर द केस मे बी. I hope you understand these two. Now the third one talks about, the clause number 3 talks about the applicability. This Article 22 applicables, the clause number 1 and 2 specifically applicable only to the citizens and the foreign aliens. On which it is not applicable, किस किस पे अप्लाई नहीं होगा? Nothing in this clause number 1 and 2 shall apply to a person who has been called as an enemy alien. I hope you get the remember of this word or get the reminiscence of this word. Where we came, this word has been came. We had discussed about the citizenship of India, part 2 of Indian Constitution, in which we had discussed about the foreign alien and enemy alien. Enemy alien are those citizens of that country with which our country has been at war. जिस कंट्री के साथ हमारी कंट्री वॉर पर है या किसी और टर्म्स पे हमें मना किया, तो इन दैट केस दैट पीपल आर कंसिडर्ड टू बी एज एनिमी एलियन. ओके. और अ पर्सन हु इज अरेस्टेड और डिटेन्ड अंडर एनी लॉ प्रोवाइडिंग फॉर प्रिवेंटिव डिटेंशन. So the clause number 1 and clause number 2, what are the safeguards have been provided? In total there are 5. Not applicable to whom? The enemy alien and those person who are to be get under the preventive detention. I hope you understand the 3 clauses of this article. Now move to the fourth one. Clause number 4. No law providing for preventive detention shall authorize the detention of a person for longer than. Now in this case, the preventive detention do not have these 5 safeguards. So the article or the constitution itself providing some of the features so that it can safeguard or should not be get into the arbitrary detention of that person, because liberty of an individual is very much important than being arrested or detention. Because in arbitrary detention or arrest, the liberty of an individual gets affected, which breaching the fundamental right to life, Article 21S, which is the most important article. Okay. Now no law providing for preventive detention shall authorize the detention longer. यानी आप 3 महीने से ज़्यादा का डिटेंशन नहीं कर सकते अनलेस अगर आपने एडवाइजरी बोर्ड से जो कंसल्टेशन है उसके रिगार्डिंग में और उन्होंने क्या दिया हो, ओपिनियन सफिशिएंट कॉज फॉर डिटेंशन, यानी सफिशिएंट रीजन होना चाहिए, रीजनेबल होना चाहिए, लॉजिकल कोहेरेंट होना चाहिए. देयर शुड नॉट बी एनी आर्बिट्रीनेस, अनरीजनेबलनेस नहीं होनी चाहिए. Provided that nothing in this subclause shall authorize the detention of beyond a maximum period prescribed by law made under Parliament. If there is any law, so in that case that terms and that condition or tenure will be taken into consideration. Such person is detained in accordance with the and whatever the provisions, जो भी प्रोविजंस होंगे डिटेन करने के, वो जो पार्लियामेंट में लॉज बनाए गए हैं क्लॉज ए और बी सब क्लॉज नंबर 7 के तहत उसके अकॉर्डिंग किया जाएगा. Now 5th and 6th the most important one. When any person is detained in pursuance of an order made any law providing for preventive detention, किसी भी पर्सन को अगर प्रिवेंटिव डिटेंशन में डिटेन किया गया है तो इन दैट केस द अथॉरिटी मेकिंग द ऑर्डर, जिस अथॉरिटी ने मेक किया है ऑर्डर, कम्युनिकेट करेगी उस पर्सन को कि द पर्सन, द ग्राउंड्स ऑन विच द ऑर्डर हैज बीन मेड, किस ग्राउंड्स पे वो ऑर्डर दिया गया है कि दैट सो एंड सो पर्सन हैज बीन फॉर टेकन फॉर द प्रिवेंटिव डिटेंशन and shall afford him the earliest opportunity of making the representation against that order. और उसको अर्लीस्ट अपॉर्चुनिटी दी जाएगी फॉर अपॉर्चुनिटी ऑफ बीइंग हर्ड, विच इज ऑल्सो नोन एज अ प्रिंसिपल ऑफ नेचुरल जस्टिस, दैट representation of making a representation against that particular order. The main agenda of this clause in Article 22, that restraining or prevention of misuse of power or authorities. Clause number 6, this is an exception, or you can show the proviso. These things or communication should not be allowed in that case where the public interest is to be disclosed. Public interest is much more important. जहां आपका public interest, आपको लगता है कि public interest affect हो सकता है, in that case you should not be allowed to be, you can do not disclose the facts to which the authority. Clause number 7, which is the most important one and on which the MCQs can be asked here, the tricky MCQs you can say. Parliament may by law prescribe the circumstances under which and the class of cases, Parliament law बनाएगा और define करेगा कौन से class of cases हैं जिनके लिए आपको may detain for a person longer 3 महीने से ज़्यादा के लिए detain करना होगा under any law providing for preventive detention without obtaining the opinion of advisory board के बिना opinion, because in 3 months, more than 3 months, if in the clause number 4 we had discussed that the opinion of advisory board has been taken. So in that case, in laws they can also, by making such laws, they can avoid such process or the maximum period as well and the procedure followed by that as well in an inquiry. I hope you got all the understanding of all the clauses of Article 22. Article 22, clause number 1 and 2 providing the safeguard in cases of the punitive detention, and Article 3 provides about the applicability. Article 4, 5 and 6 and 7 provides about the preventive detention safeguards. Now the most important question is that is only Parliament is allowed to make such kind of laws or state also allowed to make such, because we have two legislature at the union level and the state level. So in that case, what or who has the authority to make such kind of preventive detention laws? So for this you need to understand that there are 3 kind of list which has been mentioned in our constitution in the 7th schedule. हमारा 7th schedule जो हमें 3 लिस्ट प्रोवाइड करता है, यूनियन लिस्ट, स्टेट लिस्ट एंड कॉन्करेंट लिस्ट, in which the you can say that the work profile of all the levels of government has been defined कि यूनियन गवर्नमेंट क्या करेगी, स्टेट गवर्नमेंट के क्या काम है और कॉन्करेंट दोनों क्या मिलके कर सकते हैं, दोनों कर सकते हैं उन टॉपिक्स के ऊपर. सो इन द यूनियन लिस्ट एंड द कॉन्करेंट लिस्ट मोस्ट इंपॉर्टेंट थिंग्स हैज बीन on this union and concurrent list. In concurrent list entry number 3 and in union list entry number 9 state about on which factors the union can make laws, and on concurrent list on which union and state both can make laws. So here we are taking this 7th schedule, list 1 of union list. Preventive detention for reasons connected with defense, foreign affairs and security of India, person subject to detention. So यूनियन के पास किस चीज के लिए राइट्स है? यूनियन प्रिवेंटिव डिटेंशन कौन कौन से लॉस के लिए बना सकती है? डिफेंस, फॉरेन अफेयर्स एंड सिक्योरिटी ऑफ इंडिया. इन 3 के लिए यूनियन प्रिवेंटिव डिटेंशन के लॉस बना सकती है. नाउ कॉन्करेंट लिस्ट लिस्ट नंबर 3, प्रिवेंटिव डिटेंशन फॉर रीजंस कनेक्टेड विद सिक्योरिटी ऑफ स्टेट, maintenance of public order, maintenance of supply and services essential to community, persons such to be detained. Now in concurrent list, whatever the items has been specified or entries has been made in the concurrent list, the union and state can make both laws on such entries. So in that case, union has wider power and state has narrow power, because state has to be specific in such only things. Union can also make on this laws, that is security of state, maintenance of public order and maintenance of supply and services essential to the community. For such, तो on that case person subject to such detention, preventive detention के सिर्फ इन केसेस के ऊपर या इन क्राइटेरियाज के बेसिस पे स्टेट जो है वो लॉज बना सकती है, यूनियन भी बना सकती है. और यूनियन के वाइडर स्कोप है, तो यूनियन 3 चीज में और बना सकती है, डिफेंस, फॉरेन अफेयर्स एंड वन मोर that is security of India. Now the conclusion of Article 22 is that it is most important part that it wants to safeguard the individuals against arbitrary arrest and detention. इसका मेन एजेंडा था कि इंडिविजुअल्स की लिबर्टी को सेव करना, उनकी फ्रीडम को प्रोटेक्ट करना. इट एंश्योर्स दैट नो पर्सन किसी भी पर्सन को अरेस्ट नहीं किया जाए बिना ग्राउंड्स को बताए. Because the principle of natural justice is much more important, or principle of being heard, or that is much more important here. Now you need to understand this laws. Under preventive detention, what are the laws has been since so far made? First of all, that is Prevention of Terrorism Act, which has been repealed in 2004. For this, new act has been formed, that is Unlawful Activities Prevention Act, which has been amended most of the time. Now the another one is NASA, National Security Act, and the most important one is Conservation of Foreign Exchange and Prevention of Smuggling Act, that is COPSA, the act which has been also you have studied in your company's law act as well. Conservation of Foreign Exchange and Prevention of Smuggling Act. These are the following acts are known as Preventive Detention Acts. I hope you all get the better understanding of Article 22. Now, here is the summary of this Article 22, in which I had mentioned that first 1 and 2 is only representative of punitive detention. Third one states about the applicability, and remaining talks about the preventive detention. Note, in this union list and concurrent list has been mentioned that Parliament and state can both make laws on the preventive detention. And the one more case is specific to this, that is D.K. Basu versus State of Bengal. In that case, the D.K. Basu has been talked about, or the Supreme Court has provided the guidelines about the custodial violence and deaths. Because somebody has been detained and arrested, that person individual liberty has been affected. Article 21 has been affected. Article 21 has been affected, and Article 22 as well. In that case, the Supreme Court has mentioned some guidelines regarding the custodial violence and deaths. So this has been followed. I hope you all like the session. Give your reviews or views in the comment section and tell me about that, how you get that session. And subscribe the channel and hit the like button. Thank you. Have a good day.